What remedies are available for misappropriation of trade secrets? The UTSA provides a full array of remedies, including injunctive relief, statutory damages, exemplary damages, and attorney's fees for the misappropriation of trade secrets. The remedy or remedies will depend on the extent of trade secrets involved, the manner of misappropriation or conversion, and the type of damage sustained by the owner. Under the UTSA, injunctive relief is available to stop actual or threatened misappropriation. What is injunctive relief? Injunctive relief allows the owner of a trade secret to legally prohibit a former employee, for example, from misappropriating, publicly disclosing, or otherwise profiting from his or her knowledge of the trade secret. The scope of an injunction varies based on the nature of the potential misappropriator's knowledge of the trade secret and on the potential competitive advantage that knowledge might grant. The duration of an injunction is determined based on the amount of time it would take a competitor to reveal the trade secret by proper means. An injunction can be terminated when the trade secret ceases to exist, but may be continued for a reasonable period of time to extinguish any commercial advantage that otherwise would be derived from the misappropriation. In such a case, the court may still award the owner injunctive relief that is narrowly crafted to deprive the defendant of any benefit of time saved by improper use of the owner's trade secret. To determine the appropriate length of time, courts may rely on the opinions or experience of experts and competitors. They may impose permanent injunctions or rely on other considerations seen as important by the court. Where the information has not been publicly disclosed, the issue becomes more difficult. The duration of the injunction is often calculated according to the time that would be necessary for independent development of the protected information. These Head Start injunctions assume that the information could be properly obtained through reverse engineering or independent development. However, a court may also opt to impose a permanent injunction that can later be modified. How do courts handle injunctions in cases involving former employees? Courts also exhibit broad flexibility in the nature and duration of relief in cases dealing with former employees. When an injunction is issued in these cases, it usually will not be an outright ban on employment. Rather, it will be a more limited injunction for a more limited duration. Most courts are willing to allow continued employment, but will restrict the employee from working with a particular product line or area of the new employer's business. However, if the role the employee will assume in his or her new employment would inevitably lead to the disclosure of trade secrets, the employment may be prohibited altogether. What are statutory damages? Misappropriation may be awarded with statutory damages. For example, in Seagate Tech LLC versus Western Digital Corporation, the Minnesota Court of Appeals affirmed a judgment of $630 million in favor of the plaintiffs against the defendants, stemming from a trade secret misappropriation dispute. Under the UTSA, damages are measured by the actual loss caused by the misappropriation, as well as any resulting unjust enrichment of the misappropriator. Where the amount of actual loss or unjust enrichment cannot be accurately calculated, the UTSA provides that damages may also be measured by the imposition of a reasonable royalty for the misappropriator's unauthorized disclosure or use of the trade secret. What are exemplary damages? Exemplary or punitive damages may be awarded where the court finds that the misappropriation was willful and malicious. For example, in Mattel Inc. versus MGA Entertainment Inc., Mattel was found to have engaged in a prolonged practice of encouraging employees to use false pretenses to acquire competitive information from the defendant. As a result of this conduct, the jury awarded and the court affirmed a verdict of $85 million in exemplary damages. A punitive or exemplary award may not exceed twice the amount of the damage award. However, some states have modified this gap on punitive damages and allow for punitive damages greater than 2 times the amount of actual damages. In exceptional circumstances, an injunction may entitle the owner of the trade secret to a royalty for the period of time during which the use of the trade secret was prohibited. For example, the Supreme Court of Georgia has affirmed a trial court's reliance on a seldom used provision of the UTSA to impose a royalty injunction instead of an injunction prohibiting the use of the plaintiff's trade secret. A court may also award attorney's fees to a prevailing party in exceptional circumstances. A bad faith claim of misappropriation, a bad faith resistance to a motion to terminate an injunction, or a finding of willful and malicious appropriation are exceptional circumstances in which an award of attorney fees may be appropriate. However, courts are generally disinclined to award attorney's fees. The attorney fee provision is included primarily to dissuade parties from filing malicious misappropriation actions in bad faith and is considered along with the need for exemplary damages.